Hi everyone, my name's Mark Pizzacalla. This is 3 Minutes with Mark, September edition 2023. Now what I want to talk about today is employees versus contractors. I was on a plane flying up to Sydney today and I read the case JMC, and I've got to say that, it never ceases to surprise me how decisions change from one court to another. And JMC decision was no exception. But it's important because you might say, well, what's so exciting about employees versus contractors? Haven't you talked about this before? Well, I have. But it's important for two main reasons. One, obviously you need to make sure that your company, your business, is meeting its tax obligations. But secondly, from a self-interest perspective, you need to make sure, especially if you're a director of a company, that there's no unpaid tax or unpaid super. If there is, it becomes a director's responsibility, personal responsibility to get those paid. So what happened in JMC? Well, it's an education service provider. They entered into a contract with Mr. Harrison for him to undertake lectures. And essentially the first court indicated that that was an employer-employee relationship. That's fine. But that was appealed to the federal court. And the federal court looked at it more closely. And in particular, they looked at the question of control. That is, did Mr. Harrison have a real contractual power to subcontract or to assign his teaching services to another person? Because if he did, that's more like a contractor arrangement. And it all revolved around, I'll try again, Clause 5. And Clause 5 of the agreement indicated that Mr. Harrison does have an ability to subcontract out, but of course it requires the consent of JMC. Now, the federal court didn't think too much of that. Ultimately, they indicated that, look, Clause 5 was real, it was substantial, and it was not inconsistent, I should say, with that of a relationship between, a person entering into a contract and a subcontractor. It was inconsistent if you're looking at it from an employer-employee perspective. So whilst JMC could have withheld consent and not allow Mr. Harrison to subcontract, you need to do that in good faith under contract law. And you just can't say no without, having some valid reason for saying no. And in fact, factually, Mr. Harrison's role had been carried out by another person on 3 separate occasions. So that had already occurred anyway. Look, that's all I want to say. There's 3 takeaways though. Respect the contract. You need to understand what it says. What are the rights and obligations? Have a look at the cases to see where you fit in, and have a look at the circumstances in which you indicate in your contracts that there's a subcontractor relationship in place, not an employer-employee relationship in place. Real important issues. Speak soon.